My name is Tahlia Gordon. I'm currently a co-director of Creative Consequences, which is a consultancy that provides regulatory assistance and advice to organisations, including regulators of professions. Prior to being a co-director of Creative Consequences, I was the Research and Policy Officer Manager at the OLSC, and prior to that, I was the Executive Director of the Legal Profession Advisory Council and a Policy Officer at the New South Wales Bar Association. I've had over 15 years' experience in the regulation of the legal profession, and I'm continually involved in the regulation of the legal profession. I do a lot of work with regulators overseas, so I've worked with the Canadian Bar Association, the American Bar Association Centre for Professional Responsibility. I've worked with the Nova Scotia Barristers Association. I've worked with the Law Society of Upper Canada, so quite a few regulators overseas. So I'm in continuous discussions with them about what's going on in relation to regulation and what they're doing, what kind of initiatives they're starting to work on. I also attend quite a few conferences overseas. I'm a member of the International Association of Legal Ethicists. I'm also a member of the International Conference of Legal Regulators and I'm on the organising committee of that conference, and I'm also a member of the National Organisation of Bar Council, committee member on the Entity Regulation Committee and the Alternative Business Structures Committee. So I just wanted to talk about some of the things that I've been experiencing while I've been engaged with discussions overseas, and there are three things that come up continuously, and that is a focus on the regulation of non-lawyers providing legal services, which they call unregulated legal service providers. That's the common term used. The regulation of non-lawyer ownership of law firms, which is in relation to alternative business structures, and then technology and data security. So if I could talk about the first one, which is the focus on unregulated legal service providers. There's a lot of work being done, and I think that what's been happening is that regulators have become very proactive in looking at the issues. They're recognising that there are a lot of non-lawyers now providing legal services. So they've been doing quite a few studies. So the Legal Services Board in the United Kingdom has done a very recent study on the impact of unregulated legal service providers, which has been quite interesting. What they wanted to do was they wanted to assess who were the unregulated legal service providers and what impact they had on consumers. And whilst there was a lot of concern about unregulated legal service providers, the research actually revealed that they're actually working pretty well. There are a few complaints about them, but one of the problems that they found, which has been discussed here, because they're unregulated, the complaints aren't coming to the legal regulators, the complaints are coming to fair trading, which I suspect is what's happening here as well, if there are any complaints, because these online legal service providers are unregulated. They're not law firms, so people don't ordinarily complain to the legal regulators. They'll complain to fair trading departments about the conduct, about lack of transparency, about misleading information, and about service delivery. That may or may not be happening here. And one of the things that I wanted to say is we don't know enough about the extent of unregulated legal service providers in Australia. I did a very quick search and I found 5 unregulated legal service providers which all claim that they only provide legal information, although they all offer forms online, but they also provide legal advice if you seek legal advice, because you can actually ring up for legal advice. But we really don't know the extent of the services they're offering. We don't know the impact on consumers. And if we're all about protecting consumers, I think we need to play a bit of more of a role in relation to the regulation of these unregulated legal service providers and find out what's going on, find out how many there are in Australia, find out what the impact on consumers are. Find out if they have any impact whatsoever. It may well be that they're actually operating, they're fine, but we just need to find out what's going on. So international regulators have become very proactive in that area. As I mentioned, the Legal Services Board has recently done a study, and in Canada they're now starting to look at it. And in America, the American Bar Association put out an issues paper in their Futures Commission talking about unregulated legal service providers, and they've called for responses, and there have been quite a few responses, which has given them some information. But what they've gone away and said is that we really don't know very much about the unregulated legal service providers, so we're going to actually obtain some more information and do some further research. In relation to non-lawyer ownership of law firms, a lot has been going on. Everyone's looking at what Australia has done in relation to incorporated legal practices. There's a lot of angst about alternative business structures. People are very worried about protecting core values. People are very against alternative business structures. But on the other side, there's an argument that alternative business structures can provide greater access to justice. And that's actually a PhD topic that I'm looking at the moment, is whether alternative business structures like incorporated legal practices can provide greater access to justice. So people are looking at how they can re-regulate their their own regulatory frameworks and allow for entity regulation, which was what we've been doing here for a long time. People are also looking at technology, and the American Bar Association recently introduced a model rule in relation to technology and competence. And I know that we've been talking about mandatory CPD for technology, and I agree with the comments that it's great on paper, but I think that what the ABA has done, which is actually put a rule in to all of their model rules of conduct to say that you have to be competent when you use technology, and if you're not competent, you can be disciplined against that rule, is a really important substantive change in the framework that mandates lawyers really to understand the technology that they're using. And all these technologies are presenting so many ethical problems and ethical dilemmas. I mean, you've heard about artificial intelligence and the problems that can occur with artificial intelligence and lawyers using software that they don't understand. It's actually going to become a huge problem in later years as technology becomes more and more developed and the lawyers continue to use this technology without not a great understanding of what the technology is all about.
Thank you. Can I just go back to the non-lawyers? When you're referring to non-lawyers, are you talking about those who provide legal information?
Yes, so the online legal
service. Not talking about legal executives or paralegals?
No. So it's the online legal service providers. You have those, we talked about LegalZoom. We have in Australia, we have LawPath, which I think has appeared here before and given evidence. There are quite a few of them in Australia. But there are also the question and answer websites where you have justanswer.com, where lawyers are getting on and answering questions from the public. They're also largely unregulated because they're not identifying themselves as to the fact that they work at a particular firm. They now work for the organisation or the website that actually allows you to answer questions. So they're also providing legal information. They say they're not providing legal advice, but I've been through some of those processes and I've asked a few questions. They're definitely providing legal advice. I've seen what they do, but there's disclaimers all through the website. So it's those persons as well as the online legal service providers like your LegalZooms, LawPath.
Is your suggestion that they come under the umbrella of uniform law, that the provision of legal information
I think it's something
be regulated as well as legal practice?
I think it's something we need to consider, and I think that the rest of the world is actually going down that path. We've been working with the Nova Scotia Barristers Association, and they've been re-regulating their legislative framework. And what we did was we drafted legislation that allows them to regulate the delivery of legal services by lawyers and non-lawyers. So we defined legal services to include the provision of legal information, which is a very broad category, and it would catch everybody that provides legal information. But I think everyone's grappling with this group of unregulated legal service providers that are not regulated by anybody.
Have you been able to ascertain whether complaints about the information providers in their overseas jurisdictions, are those complaints going to the equivalent of fair trading over there?
Yes, they are. Yes, complaints are going to equivalent of fair trading.
And how do the fair trading bodies deal with those complaints as simple consumer complaints?
Simple consumer complaints, which means that the providers are not being educated as to how they should be dealing with the provision of legal services. So it's a different regulatory framework, and there are no standards being set as to what kind of advice you should be providing, no standards of professionalism or ethics. There's nothing being placed over them. But in addition to what Nova Scotia has done, and other jurisdictions are following down that pathway as well, they're also focusing on entity regulation to capture these online legal service providers. So basically, if you're an entity that provides legal services, you're going to be captured under that regulatory framework, and they've developed an entity regulation framework which is very similar to our framework, which we help them deliver, which sets out 10 objectives. So anybody that delivers legal services has to comply with this regulatory framework for entity regulation.
The ultimate sanction for a lawyer who breaches the regulatory framework is being struck off. What is the ultimate sanction for a non-lawyer?
Well, obviously you can't be struck off, but basically they are stopped from delivering legal services. But this hasn't happened yet. So the framework is actually in the process of being implemented. So legislation has been drafted, and it hasn't been implemented yet. So we have to work through all of those different scenarios. But the idea is that they're stopped from providing those legal services.
Can I then jump to artificial intelligence? Is your concern that lawyers potentially may be slavishly relying on what a computer tells them is the answer or solution to some issue, rather than actually thinking about it themselves?
I think that's happening. I think that's the whole purpose of artificial intelligence, is take away the thinking behind the answer and just provide the answer. I think that probably is happening these days. I think that obviously it depends on the lawyer who actually receives the information about whether they want to engage in a conversation with their client. To the extent of the conversation, that's up to that particular lawyer. But I think that the natural stance is to actually get the information and to pass it on without thinking about it, because that's the point of artificial intelligence. It's quick, it's cheap, and it's efficient.
And hence the need for lawyers to understand the technology.
I think it's not just artificial intelligence. I think that lawyers need to understand there's such a vast array of technology around at the moment. All of these apps that keep on being developed, they're fantastic, and I think that each one of the apps has value. But I think that it's really hard to understand how you use an app ethically when you're in the practice of law, when you haven't had to use an app before, and what that means for the client and how you actually relate to the client when you have an app that's helping you do work. There's a whole range of ethical issues around the use of apps. I mean, whether you disclose to the client you're using an app, whether you disclose to the client you're using artificial intelligence to obtain an answer. I just don't think that we're thinking enough about how to use technology ethically in practice.
Do you think that also extends to, with, say, apps and artificial intelligence, I suppose a lawyer would need to really understand what process the AI goes through, what process the app goes through, which perhaps an app owner or AI owner might claim is intellectual property and wouldn't be shared.
Right.
Do you see that raising significant concerns, that if you don't actually understand the thinking process and logic behind...
Sure, but I'm not sure you need specifics. I think you need a general idea about how the information comes to you, how the software works. I don't think you need to know detail, just an understanding of what information you put in and how it comes back to you. I think that's really important. I think it's also really important to understand who the providers of the software are and making sure that they're actually accredited, making sure that, they're abiding by ethical frameworks, making sure that they have, confidentiality provisions and they're keeping information secure. I think lawyers have an obligation to ask those kinds of questions. It was very much the same a couple of years ago in relation to cloud computing, that we were asking those kind of questions, and we drafted guidelines in the past. People are now starting to think about guidelines in relation to AI. There's a lot of discussion overseas about whether we need a guideline in relation to AI. I think that's going to be the path now for regulators, is developing guidelines. And they're not rules and regulations, they're just guidelines to assist the profession. So they're not regulatory burdens, they're basically to help the profession how to use these technologies more ethically.
Are there any other trends or issues that you can see developing that might affect the way in which legal services are provided or the way in which law is practiced?
I think the major trend is actually alternative business structures and the use of external investment in law firms. And it hasn't actually been permitted in America yet, although they're very much going down that path, even though they deny that they're not. And Canada is also going down that path. I mean, external investment and non-lawyer ownership of law firms has radically changed the legal services marketplace in England and Wales. Singapore is now going down that path, and Scotland is now going down that path. And I think we'll see a radical change when external investment is allowed in North America.
Are they watching what's happening here?
Absolutely. I continuously get asked questions. In fact, last week I did an ABA webinar. It was Alternative Business Structures Perish. That's basically the title of it. They're very much aware of what's going on here. I continuously talk to them about the research that we've done, the fact that the sky hasn't fallen in as a result of external ownership of law firms, the fact that the research that I did, there was a much greater reduction in complaints in relation to incorporated legal practices. That was quite a few years ago. There haven't been complaints that law firms have been preferring shareholder interests over their clients or the duty to the court. So I'm continuously talking to them about that. The biggest problem is that there's an argument out there, as I mentioned before, that external ownership increases access to justice. And unfortunately, it hasn't really been proved yet. But that's what everybody is basing the argument for alternative business structures on, is that there's a link between that and access to justice. So I'm working through that to try and have a look at whether that exists or not. If you have a look at Slater and Gordon, which is obviously the big elephant in the room, I did a little bit of research and it does show that with external investment, Slater and Gordon has been able to buy greater firms and invest in technology and provide greater legal services to their client base. that's really just one example. I had a look at Shine Lawyers as well, but there has never been an in-depth study on the link between alternative business structures and access to justice.
Yes, it's hard to conceptualise how that link achieves that outcome.
Well, basically, you have to have a look at the structure of the firm, and if the firm has incorporated or if the firm has listed, you have to have a look at the amount of external investment that's gone into the firm and how the firm has actually used that external investment. So there have been a few studies in the UK on firms like Riverview Law and Co-op Legal Services on how they've actually used external investment and what they've done with the money that they've received and whether they've put it into technology or whether they've bought more firms. There's a trend, and it certainly suggests that external ownership increases access to justice. But there's also a trend that says external ownership, access to justice is also increased by unregulated legal service providers.
Or more investment in community legal centres.
Right, absolutely, absolutely.